Okay, so we are in week 12. This is a week 12, um, the week 12 video lecture for legal research. We are on chapter 15 of your text. The title of that chapter is Strategies for Effective Writing. So far we've gone through just kind of this preparatory process for getting your writing organized and getting your writing skills kind of polished off to make sure that you keep in mind the importance of who you're writing for and why you're writing. Remember, when you're doing legal research and writing, you're writing for a judge, you're writing for an attorney. You want to make sure you are persuasive and informative. Those are the goals here. There's nothing else. There's no cutesy, there's no hooks that you put in. You have to be organized so that you can get all your legal research in an presented in an organized, complete fashion. And you need to make sure your grammar and your punctuation are appropriate so that, number one, you're persuasive, and number two, you don't draw attention away from yourself or your argument. Okay? Now, this chapter is now where we've done our research, we've organized our thoughts. Now what? Now what? What are we going to include so that we make sure we meet those goals of being both informative and persuasive? So this chapter talks about, first of all, the kind of language you use. Look, I'm not a big 50-cent word person. I don't think that you need to impress your reader with words that they have to stop, go and look up, and then come back and read. What's the benefit to that? How are you persuasive? How are you keeping the flow of what you're writing going? Your book talks about this plain English movement. It's important that you know who you're writing for. If you're writing for a judge, and you know you're writing for a judge, and that judge has written articles on a topic that you might be able to roll into whatever it is you're presenting to the court, smart. Most of the time you're not going to have that kind of I think I got a hook here. Most of the time you have to rely upon your words, your sentence structure, and your organization to bring that judge along to your perspective. Okay? Your book talks about plain English kind of guidelines for making sure that you're not throwing in 50-cent words because you think you're a smarty pants, and making sure that you're sticking to your topic at hand. The first is use short sentences. In our last chapter we talked about run-on sentences, and people, that reminds me of people that you're listening to that you just want to say breathe. It doesn't have to be that long. Short sentences ensure your writing is sticking to the principle of short sentence equals one idea. You're not smushing a lot of ideas into one sentence, which goes on and on forever when you use short sentences. Understand, too, that short sentences have a certain clarity to them. When you are keeping your sentences to, say, 10 words, you got to choose your words carefully. And you want to make sure that you are highlighting the language that you think will persuade the most. And so there's not a whole lot of superfluous kind of junk thrown in, and it's not a sentence that equals a paragraph that's 7 lines long. It's to the point. Especially when you're doing legal writing, remember, you are trying to sometimes convince the court on several different issues, and you've researched these issues, and you've slept with these issues, and you've breathed these issues. You know what you want to say. But the judge hasn't done all of that. And so when you start mixing all those issues together, it's confusing and it's not persuasive. So short sentences are a way that you can sort of put a guardrail up for yourself so that you don't go into run-on sentence land, that you don't go into squishing together all these issues land. You're sticking to the point. The second thing that your book says is use definite, concrete, everyday language. Translation, no 50-cent words. If you are using words that the average person would have to look up, find a different word. Unless you're quoting a case, find a different word. Just say it. Don't dance with it. Just say it. The next thing your book says is use the active voice rather than the passive voice. So what does that mean? Active voice is when someone is actually doing something. I bought bananas. That's active voice. Someone is doing something. It's easy to connect those two. Passive voice in writing would be the bananas were purchased. By whom? I could even throw in the bananas were purchased by me. Okay, that's a lot of extra words. The bananas were purchased by me is a heck of a lot longer than I bought bananas. 3 words versus what? 6 words. Short sentences. Active voice almost all the time will give you shorter sentences, and it also doesn't dance with a topic. You know, something was done by somebody. What? No, somebody did it. That's the way that you want to approach it. Now, I will tell you, a lot of times defendants, lawyers, particularly in criminal cases, will really lean heavily on passive voice because they don't want it to look like their client did anything, right? The store was robbed instead of my client robbed the store. Then you're not really doing your job well. So the only exception that I may throw out there for active voice versus passive voice is when you're trying to deflect, like in criminal defense cases and you're the defendant and you're the lawyer for the defendant, sometimes passive voice is a little more helpful than active voice. But active voice is cleaner, it's shorter, it's easier to understand, and I will tell you, sometimes it's hard not to write in passive voice. It sounds a lot smarter, right? Something was done. The event happened. Well, what was the event? Who did it? Who, when, where, what, how? Remember those questions in our organization of doing our legal research? Put that into your sentence. It's cleaner, it's shorter. Everybody will appreciate it. Use tables and lists to present complex information, and avoid legal and financial jargon and highly technical business terms. Why do I put those two together? Sometimes when you're writing a brief or you're writing a motion, you can attach as an exhibit a graph, some kind of visual aid that's been prepared by maybe your expert. It's a lot cleaner that way. You know, a picture what says is worth 1,000 words, right? Okay, so that's how you get a picture into your legal memoranda, your legal brief, your legal motion. You will attach it as an exhibit. You can't prepare that exhibit. It's got to be prepared by someone who's testifying, somebody who can say, hey, this is what my research shows, or, you know, someone who gives credibility to whatever graph you want to or table you want to attach as an exhibit. Because remember, nobody cares what you think. You are irrelevant. You are simply the persuader. The law, according to Diane, does not exist. A table that's prepared by Diane, who cares? Right? But if you have an expert who prepares a table and you have some of that testimony in your whatever it is you were writing, attaching an exhibit prepared by that individual sometimes helps, especially when you've got complex topics, engineering topics, or mathematical topics. If you have something attached, it's a picture, it helps. It's persuasive. Okay? And again, not using legal and financial jargon, put that into a table, put that into a graph. Anybody can look at that graph and get it. Using all kinds of very technical language, again, is not going to help your reader continue to read. If they have to stop in a paragraph and say, what in the heck does that mean? Put down whatever they're reading that you've written, go and Google it, and then say, oh, I think that's what that means, right? You're not being clear in your writing. If somebody has to look up what it is you're saying, how persuasive can you be then? You can't be. So that's why, this is part of the advice. Avoid double negatives. No one does nothing. Double negative. What does that really mean? Everybody does something. Again, this kind of goes to active and passive voice. Clean it up. Make it short. Make it concise. Don't dance with the words. Just say it. Okay? Avoid weak verbs, abstract terms, and superfluous words. Kind of all goes back to the first one. Use short sentences. Don't dance with the words. Enhance readability through attractive design and layout. Okay, well, for legal stuff, it doesn't really apply. It's kind of a form that you have to use, paragraphs, whatever. But what I would put into here is don't use typos. Double check your words. Nothing is more of a hindrance to the readability of whatever it is you're writing than typos. Spell check doesn't catch everything. I'm sorry to tell you. So make sure you read, reread, have somebody with a fresh set of eyes read what it is you've written, just to make sure that you haven't misspelled something, or put an apostrophe in the wrong place, or a comma that you're not sure about. Because it's very distracting when you're reading something and there's a misspelled word. I could be 2 pages further in and I'll be thinking about that misspelled word. Why are you going to distract from what you've written? Why are you going to make it harder for your reader to pay attention? It's counterproductive, so don't do it. Okay? Now, your book then suggests, as you actually begin your writing, a pre-writing phase. I think that in the old days when I went to school, they were talking about do an outline. What's an outline? An outline is where you organize your thoughts in a lot more detail than you did when you were just kind of putting the research together. Where you kind of put your words that you want to make sure to get in there. You organize your sentence structure so that you make sure there's a flow to how your whatever document reads. It's not choppy. So organizing in outline form is important. As one of your assignments for this week, I'm giving you a link on writing outlines, and I'm going to have you do that as one of your assignments. Okay? Your book says make sure you use precision in the language you use. Again, if you're shortening your sentence, words are important. You're not going to have a bunch of fluff in there. Make sure your words mean what you think they say. Effect. This is one of those kind of things that most proofreaders kind of cringe at. Affect with an A is a verb. I affected the outcome of the story. Effect with the E is a noun. The effect is fill in the blank. Okay? Make sure you use the right one. Again, spell check won't get this. Spell check will say, yes, affect is a word. You used it incorrectly, but it's a word. Now, there are proofreading software programs that will look at what you've written and make suggestions based on making sure there's active and not passive voice, making sure that your sentences aren't run-on sentences, making sure your punctuation is correct. If you are unsure about your writing, use them. Use that software. I'm a big proponent of work smarter, not harder. And I will tell you, the more that you write, the better you get at it. And using this editing software as a crutch until you get up to speed or where you feel like you're up to speed is okay. There's nothing wrong with it. But you ought to be able to write without that program eventually. Okay? Among and between. Among is when we're talking about 3 or more. Between is 2. Okay? There was an argument among my 4 children. There was an argument between my 2 children. Different. And or. It's either or, neither nor. Okay? Make sure that you're using those words correctly. Apprise and appraise. Apprise means that you're informing somebody. Appraise means you're telling the value of something. Okay? Now your book goes through some more. I'm actually going to include some of those in your assignments for this week. It's important that you practice your word skills. And these are just some of the words that people trip over regularly. That's why they're included in your text. Okay? Now, we want to be precise in the language we use. Therefore, we really don't want vague words. What do I mean by that? Or a vague phrase. You know, when my 18-year-old son gets up in the morning and I say, hey, how late were you out last night? Oh, pretty late. Not too late. Not too late. What does that mean? Nothing. Because my idea of what's too late and his idea of what's too late, 2 different things. I've learned this. He's child number 4, right? And so I press him. Well, what do you think is too late? Oh, I don't know. 2 in the morning? That's too late. Oh, okay. So were you in before 2? Were you in before 1? Were you in before midnight? Until I can pin him down specifically. One of the best people, or some of the best people I know who use vague words are politicians. Right? Hope and change. What does that mean? My idea of hope and change and your idea of hope and change are probably 2 different things. So sometimes, for a certain kind of written communication, you are going to be intentionally vague. Legal research, not so much. You do not want to be intentionally vague. Again, caveat, if I'm a criminal defense lawyer, sometimes I'm going to be a little bit vague. Just a little bit. Okay? Not going to lie. I'm not going to fudge. I'm just going to intentionally use vague words. Okay? If I'm trying to persuade somebody, though, usually vague is not the way I want to be. I want to be more precise. Okay? Also, you want to be aware of the connotations of words. If I say that someone's thrifty or good with a dollar, those are kind of positive things, right? But if I say they're cheap, wow, that's not so nice, is it? The word that you use will have kind of a feeling about it. And you need to be aware of that. And that's just everyday language. Everyday language. Someone who is fashionably late, that's not terrible, right? That doesn't have a terrible connotation. Somebody who is habitually late, oh, that's not so nice. So make sure that when you're using words, you consider the totality of how that word is used in everyday language. And then choose the best word possible for your short sentences to persuade, convince, get somebody to see the world your way. Okay? Hang on just one second. The next thing that your book talks about is you want to be clear. And this is really kind of the same idea. We don't want to use passive voice. We want to make sure that our writing is clear. One thing that I do like in this section, because this is how I like to write, so I'm a little biased, lists. If I'm writing something for the court and I'm filing a motion, and I want the court to do 1, 2, 3 things, in my opening paragraph, I'm going to say, I want the court to do, colon, because remember we put a colon before a list, parentheses number 1, put it out, parentheses number 2, put it out, and parentheses number 3. Why do I do that? Readers need expectations. Excuse me. Readers need to know definitively, especially if you're writing for a judge, what do they want me to do? Why are they filing this motion? What's this all about? Remember, you live the case. You know the clients, you know the situation, you know the law, you've agonized over about it, you've key cited things in your dreams about the case. You've lived this case. So the judge hasn't done that. So when you're writing something for the court, it's helpful to the court to say, hey, I'm going to go over 1, 2, 3, 4 in this motion. Then the next section will be section 1. Oh, that's right, I saw that. You said you were going to do 1, 2, 3, 4. There's number 1. Then when you finish with number 1, you're going to do a new heading, number 2. Oh, it's easy to read. Then I'm going to get to number 3, then I'm going to get to number 4. It's organized. It is a way for the court or the reader, whoever the reader is, to follow along with whatever organization you have for this particular document. Always helpful to the reader. I will tell you, because I've done this, if you're going to say I'm going to do 1, 2, 3, 4, you better do them in that order. Because if you say I'm going to do 1, 2, 3, 4 and you start with number 3, the reader's going to be like, what just happened? I have no idea where this guy is taking me. Okay? If you're going to be organized. Put things in the right order. Okay? All right. And again, your book says avoid legal jargon. Use forceful words. True story. First motion I ever wrote when I was in law school for a lawyer that I was working for. At the very end of, I think it was a complaint that I wrote, I put, wherefore plaintiff respectfully asks the court to. And I said what we wanted the court to do. And the lawyer that I was writing it for said, no, we don't ask, we demand. We don't pussyfoot around here. Wherefore, plaintiff demands judgment as follows, colon, 1, 2, 3, 4. It's forceful, it's succinct, it's organized, And there's no question what we're doing here. We're demanding it. Okay? If you are writing for the court, you must be very clear. And you have to be forceful in doing that. You can say things in a persuasive document like, defendant makes this argument has zero merit or is ridiculous. I've done that before. Not made ridiculous arguments, argued that their side was ridiculous. Okay? It is okay for you to succinctly draw attention to what you believe are false arguments being made by the other side. And that's typically when you're going to use that kind of forceful language. You could say, defendant presents an absurd argument, or there is zero merit to this argument. It's important that you understand we're not playing nice. This is scrapyard language, dressed up in like, oh yeah, we're all fancy wearing our suits to court. You need to make sure that in your writing, everybody knows where you are. Your book also says repeat strong phrases over and over. That is a technique that's called the persuasion of repetition. Any of you who have small children know that if a child wants a cookie, they're not stopping until they get a cookie. Can I have a cookie? No, you can't have one. Can I have one after dinner? No, I can't. If I have one, you can have one. I love you so much. You make the best cookies. I just want to take a cookie to my sister. Can I have one too? Why can't I have a cookie? Right? Until you finally lose your mind and say, have the blessed cookie. Repetition is persuasive. One of the best kind of techniques for doing that is at the end of a paragraph or at the beginning of a paragraph, repeating a phrase. Accordingly, defendant's argument fails on its merits. And you do that again in the next paragraph. It fails on its merits. Defendant's argument fails on its merits. And then in your conclusion, you can repeat that again. Just so there's repetition as to what your position is in whatever it is that you're presenting to the court. Repetition works, especially if it's one of your strongest points. Hammer it, right? Lots of times students will say, gosh, that's so much repetition. That's the point. The point is to continue to repeat it until they sleep and they hear it in their dreams. Okay? That's how you're persuasive. Okay? And your book goes through making sure that you keep your sentences short. Are you seeing a theme here? You want to make sure that everything stays short. Okay? Now, your book goes through how to do outlines. Again, the exercise I'm giving you actually has, I think, a bit more meat to it in doing outlines, so I'm going to rely upon that, and I'm going to skip over to drafting techniques. First of all, you better know when whatever you're writing is due. You work backwards. So if I'm writing a motion for the court and the motion is due on September 12th, I'm going to put it on my calendar for September 9th or even 8th. Why am I going to do that? Well, because things happen. And this way, as things happen, you've built in a little wiggle room. Okay? That's the first thing. Know when it's due and backdate it a few days. And then start putting together how much you want to get done each day. Because remember, if you're working in a law office and you have a motion due, that's not the only thing that's on your desk. You have that motion, you've got discovery over here, you've got a deposition over there, all happening on the same day. And so you have to pace yourself. and you have to set deadlines for yourself. Now, there are a lot of people who are like, oh, I work better under pressure, or that's just an artificial deadline. I can't convince myself to get it done by that date. Well, you better learn. Because if you're in a busy practice, ain't nothing good gonna happen. Like all those double negatives in the word ain't when I'm talking about writing. Nothing good is going to happen if you do not set artificial deadlines for yourself to be at certain points in the drafting of this before your artificial deadline of when this thing is due. It's important. Now, there are software programs that will help you. There are programs that you put in, okay, this motion is due on September 9th. And it will every day remind you, it has been 4 days since you worked on this motion. I use a program called Amicus. And literally, when I'm doing my writing for my business, I'll put in, due on this date. And then I will put in my deadlines. And when I turn on my computer every morning, I'm greeted with a beautiful voice from the software program. Good morning, Diane. It is now August 15th, and you have 20 days to get this motion done, or this brief done. I see you have not worked on it for 3 days. When would you like to work on it today? At which point I scream at the computer, and I start working on what it is that's due. Because I know, because I'm old, that if you do not pace yourself, it won't happen. Won't happen. I'm way too old to pull all-nighters. And I also know that's not really my best work. So I need to pace myself. That's your first thing. Okay? Now, I am a big write things out by hand, right? You can see here I've got everything written down. I am a pen and paper kind of gal. I have segued a little bit for using Westlaw and folders and highlighting and taking notes on the cases themselves digitally. But at some point, I have to organize everything, and I like to do my outlines on paper. You may not be that kind of person. Doesn't matter. However you write best, write. If it's better for you to do an outline on a split screen so you can look at your outline and then type the text on a different or on 2 different screens or on your phone and then on whatever works for you, do it. If it's not working, switch. That's the key that you have to remember. If you are stuck, if you can't get that outline to type up, if you've got a block somewhere, switch to paper. Or if your paper looks like, your 2-year-old got a hold of your pen and scribbled, then switch to the digital. Whatever works. You have to know what's working and what's not working. That's the key. Okay? Some people dictate. Okay? There are plenty of programs out there. We use one called Dragon, where you do voice to text. So maybe I'm looking at my handwritten outline and I'm talking to my computer and my computer's typing it all up. And that's not a maybe thing, that is what I do because I'm a terrible typist. One of my biggest regrets is not taking typing in high school. So for me, dictating is a better way of doing things. In the old days, and I'm sure a lot of people still do this, they dictate into a machine, a digital machine, and then that goes to whoever their assistant is, their secretary is, and they put it in final form. For me, I'm a one-man show, so it's just easier for me to talk to the computer. Okay? All right. That is really it for this chapter. Like I said, I'm going to give you some assignments, including an outline assignment. There's going to be 3 assignments plus a discussion for this chapter. Okay? So just keep that in mind. It all evens out in the end. Some of your modules only have 1 assignment, some have 3. it'll all work out. Okay. But I think it's important for you to know how to organize your thoughts so that you can get what's in your head down on paper, even if the paper comes out of the printer. Okay? Have any questions? Email me, text me, let me know where you're at, and I will help you however I can. All right? Thanks so much.